Welcome to the weekend. I'm Eugene Daniels along with Jonathan Capehart, who is out at the Aspen Ideas Festival. Jackie Alemany is on parental leave. We begin with the U.S. Supreme Court, which has just handed President Trump a major victory, curbing court injunctions that halted his plans to end automatic birthright citizenship. In a decision steeped in historical analysis, the majority argued in part that because nationwide injunctions did not exist in the High Court of Chancery in England at the time of this nation's founding, lower courts had overstepped in blocking Trump's executive order. You'll remember, of course, we fought an entire war to be able to make our own rules and laws. Notably, the court did not rule on the constitutionality of Trump's move to end birthright citizenship. But in a scathing opinion, Justice Sonia Sotomayor writes, quote, "The gamesmanship in this request is apparent, and the government makes no attempt to hide it. Yet shamefully, this court plays along because I will not be complicit in so grave an attack on our system of law. I dissent." Trump's executive order is now set to take effect in 30 days. Lower courts are already taking action, setting deadlines for amended complaints to comply with the Supreme Court's new ruling. Joining us now to get into it is Michelle Goodwin, professor of law at Georgetown University and host of On the Issues at Ms. Magazine, and Mark Joseph Stern, senior writer at Slate. Michelle, I want to start with you because it doesn't seem like we got a lot of information in how this is actually supposed to work. What is the roadmap for folks as we move forward over this next 30 days and beyond?
Well, it's a bit of chaos, and unfortunately, we heard in oral arguments just what's at stake, which would mean that all across the country, individuals who are affected by this would have to secure a lawyer. Many of these people are probably going to be vulnerable in some sense, economically vulnerable to ICE, et cetera, to end up defending themselves against this executive order. There's also the tragedy that we've seen in other instances that have paved the way by anti-abortion states, where they have law enforcement willing to go into hospitals and maternity wards. Might we end up seeing ICE in those spaces as well? What has been unleashed is a chaos that is absolutely hypocritical, because this very same Supreme Court during the Biden administration was willing to entertain nationwide injunctions against the Biden administration over and over again without seeing that there be any problem. And one last thing I'd like to add to this. In this opinion, what the court talks about is equity. What could be more equitable than thinking about a person's belonging, their citizenship, and their personhood here in the United States? This really is a travesty.
Mark, help me. I'm still deep in the weeds here, trying to understand the practical effect of what the Supreme Court did yesterday. So after the 30 days is over, does that mean children born in the 28 states that weren't a party to this lawsuit, the children born in those states won't be American citizens until which time the question gets to the Supreme Court and the Supreme Court decides on the constitutionality of birthright citizenship? Am I following this right?
That is one very possible outcome, because the Supreme Court suggested that the injunctions here have to be limited to the parties, and 22 states were parties, then children in those states should still be protected. But as you said, 28 states were not parties to this suit. And so the court implied that perhaps the injunction should not extend to those states and children born within them, which means that there could be an underclass, a new caste of newborns in 30 days who are stripped of American citizenship, even though it is their birthright under the 14th Amendment, and who are rendered deportable and quite possibly stateless from the moment they join this earth, which is a really startling and jarring outcome that the court barely bothers to address. I mean, you know, as Eugene indicated, this is a really kind of arcane and esoteric opinion. This is Amy Coney Barrett putting on blinders, in her majority opinion, to the devastating consequences of the ruling, not even considering the fact that the executive order here is patently unconstitutional under any reasonable reading of the law and 120 years of Supreme Court precedent. Now, there's a chance that the judges on the lower courts who have these cases might try to scramble and come up with other relief. Some of the lawyers have already tried to certify a class action as a substitute for the universal injunctions and say that they are representing every person who is affected by this order all across the country. That might work, but in a concurrence, Justice Alito, joined by Justice Thomas, warned that courts should not replace universal injunctions with class actions, that that's too much of a stretch as well, and that these kinds of relief should still be limited to individual plaintiffs. And if the lower courts are bound by that rule, then in 30 days, we are going to have, for the first time since before the Civil War, a new underclass of babies born of immigrants who are stripped of one of the most fundamental rights there is.
Michelle, I want to play some sound from the president from a press briefing that he did on Friday and then get you to respond on the other side.
Thanks to this decision, we can now promptly file to proceed with these numerous policies and those that have been wrongly enjoined on a nationwide basis, including birthright citizenship, ending sanctuary city funding, suspending refugee resettlement, freezing unnecessary funding, stopping federal taxpayers from paying for transgender surgeries, and numerous other priorities.
The list, as the president indicated, goes on and on and on, the kinds of things that, one, this White House feels like they can do and the things that may already be affected by this ruling. Like Justice Sotomayor said, they weren't hiding the ball. This wasn't really about the 14th Amendment and birthright citizenship, right? This was about the ability for district courts to make nationwide, make rulings that affected the nation on issues that are of national importance. What does that do to the rule of law and kind of how we operate and have operated? And what are the impacts of that on everyday people, other than having to get lawyers possibly?
Well, one of the first things that I want to say, Gene, is that what the court did yesterday was also to show incredible disdain toward lower court judges. And it's notable that those of that 6 super conservative majority, individuals who've not served on district courts. I've been reminding people that Justice Ketanji Brown Jackson really is quite experienced, more experienced than many of her peers on the Supreme Court, given that she's served across various judicial branches. But look, this makes scorched earth of the rule of law, something that is critically important. The rule of law means that the court will be predictable, that precedent will matter, that the court will uphold constitutional values, that the court will pay attention to civil liberties and civil rights. And what we see is that that has been abandoned. We see across a series of cases where the court has allowed the weaponization of the First Amendment on religious grounds. We've seen the court be opportunistic with its originalism. It cares about originalism on one day. It doesn't care about originalism on another day. It's willing to say that nationwide injunctions are fine against the Biden administration, not fine in a Trump administration. And ultimately, what the Supreme Court has shown is that it's willing to give significant deference to the Trump administration, even on matters that are absolutely unconstitutional, as Mark just said, and also illegal. And we know that's the case through many of these executive orders. And it's worth noting that district court judges that have put a stop on them are district court judges that are Republican appointed, and some of whom have been appointed by Trump himself, who've said that these are blatantly unconstitutional and un-American.
Hey, Mark, you mentioned a moment in response to my question to you earlier. You mentioned Justice Amy Coney Barrett having blinders on. And I just want to point something out that I don't know if folks have picked up on this or even know about this, but Justice Barrett gets personal going after Justice Jackson's dissent. And I want to, let me read you this from this story, or from her dissent. We will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself, wrote Barrett. We observe only this: Justice Jackson decries an imperial executive while embracing an imperial judiciary. All right, Mark, look, this seems to me, when I read this, it seems to me that the comity that we have long known about the Supreme Court is gone. Like, the gloves are off when they're getting this seems to be a very personal response from one justice to another. Or am I reading too much into it?
It's very personal, and I think it's extraordinarily disrespectful and inappropriate from Justice Barrett, who touts herself as being collegial and professorial, but in this case clearly felt wounded by Justice Jackson's critiques. I think Jackson's blows clearly landed here. And Barrett responded with what I do agree is a far too personal retort that accuses Justice Jackson of not really being smart enough, I think, to levy a strong criticism of her opinion. That's totally out of bounds. It's highly unusual. Even when the justices disagree, they usually do so respectfully. And here, Barrett is going much further. And I think the reason why is really obvious, right? Justice Jackson's dissent is one of the sharpest, fiercest, most blunt dissents we've ever seen. She is taking on the Supreme Court as an institution in the conservative supermajority. It's one of several dissents she published this term where she accused the supermajority on the right of bias toward the Trump administration, of surrendering the rule of law so that Trump can rule like a king, of essentially degrading our constitutional democracy and turning it into a monarchy that Trump can rule by himself. And she's saying not just that the majority is doing this by accident, that it's stumbling into this, but that it's doing it on purpose, because this is how the majority sees the country, that they really believe Trump should rule it with no limits. And, you know, I think after this decision, it's kind of hard to argue with that, right? You know, the majority sees a policy that is so patently unconstitutional, and rather than understand that that's the emergency that courts need to address, it turns around and smacks down the lower courts and says, you went too far. So Jackson's criticism there was entirely appropriate, and for Justice Barrett to act so wounded and respond so personally is really out of bounds, disrespectful, and arrogant.
You know, the Supreme Court Justice Jackson, in her dissents, all dissents are written for history, but certainly hers surely are. Mark Joseph Stern, Michelle Goodwin, thank you both very much for coming to the weekend.